Good morning and welcome to all. It is now 10 a.m. and I would like to formally open this preliminary meeting for the Mooir Vannin Offshore Wind Farm project. Before we introduce ourselves, I want to cover off a few housekeeping matters. Can I confirm that everyone in the room can hear me? And people online? Okay. Can I also confirm with the case manager and the audiovisual team that the live stream and recordings have started? Yes? Okay. Can everyone present in the room please turn off all your devices to silent, put them on silent. Very quickly, toilets are located just outside those doors over there. There are no planned fire drills during this event, so if you hear the alarm, it is real. In the event of a fire, we will exit the building via the doors to my right and congregate in the car park. Right, on to panel introductions. My name is Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act of 2016, or MEMA for short, to chair the panel of examiners for this application. I confirm that I've made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, that I do not currently and since my appointment, I have not had any professional involvement with Ørsted, which is the applicant, the Department of Infrastructure, and any other department or agency in the territory of the Isle of Man. For context, I have been an examining inspector and chaired examining bodies such as these in relation to nationally significant infrastructure projects promoted across the UK from 2016 to 2024, where I have discharged my duties to examine with openness, fairness and impartiality. I'm a chartered member of the Royal Town Planning Institute, which means that I am bound by the Code of Professional Conduct, which sets out ethical standards for all members of the Institute to meet, including the requirement to operate with honesty and integrity and to exercise independent professional judgment. This underpins my commitment to conduct these proceedings in a manner that is independent and procedurally fair to all. I will now hand over to my fellow panel members to introduce themselves. Ms. Fernandez.
Good morning, everybody. My name is Frances Fernandez, and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I've also made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm I do not currently and since my appointment, I have not had any professional involvement with Ørsted, the DOI, or any other Isle of Man department, agency, or business. For context, I have been an examining inspector in relation to nationally significant infrastructure projects since 2010. I am also a fellow of the RTPI, which means I am bound by the Code of Professional Conduct, which sets out ethical standards of members of the Institute. I operate professionally within the same professional and ethical framework that Ms. Sahai has just set out.
I'm Ms. Pownell. I'm a member of the panel member appointed pursuant to Section 27 of MEMA. I confirm that I've made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm I do not currently, and since my appointment, have not had any professional involvement with Ørsted or the DOI or any other Isle of Man department, agency or business. For context, over the last 35 years, I've been integrally involved in consenting, application and construction of major infrastructure projects across the UK. I'm also a chartered member of the RTPI, which means I am bound by professional code of conduct in the same manner as does the other panel members and frames my conduct in this examination.
Good morning, everybody. My name is Mr. Smith, and I am also a panel member appointed pursuant to Section 27 of MEMA. I confirm that I too have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, I also confirm that I do not currently, and since my appointment I have not had any professional involvement with Ørsted or the DOI or any other Isle of Man department, agency or business For context here, I've been an examining inspector in relation to nationally significant infrastructure projects in the UK from 2012 until 2025. I served as the head of profession for planning inspectors in England and Wales from 2008 to 2012. I also served as the equivalent of an examining inspector for infrastructure in the state of Victoria, Australia from 1999 to 2005. I too am a chartered member of the RTPI and am bound by its code of professional conduct in the same manner as my panel member colleagues, and it frames my conduct in this examination too.
Thank you very much. Together, the four of us, we constitute the examining body for this application. For all examination-related matters, we will be addressed formally, either as Ms. Pownell, Ms. Fernandez, Mr. Smith, Ms. Sahai, or Ma'am and Sir. Having provided these introductions to the examining body and explained the approach that has been taken to our appointments and declaration of interest, I will note that we do have some people attending today who want to speak about the appointment of the examining body. Now is not the time, but I will bring you in at agenda item 2. I will also note that in future meetings and hearings starting this evening, we will not provide detailed introductions of this nature. Anyone wishing to review these introductions will be able to do so using the note of this preliminary meeting, which will be published as soon as practicable. Also present today are members of the Cabinet Office case team, notably Mr. Tom Randall, who will provide procedural support throughout the examination process. And the audiovisual service is provided by Energy Media Limited. Now, just a few words about how I intend to run the meeting followed by the purpose of the meeting today. Today's meeting is being undertaken in a hybrid way, meaning some of you are present with us at the venue and some of you are joining virtually using Microsoft Teams. Some of you have chosen to watch the live stream, and additionally, a recording of today's meeting will also be made available on the MEMA website as soon as practicable and after the meeting is finished. With this in mind, please ensure that you speak clearly into a microphone, stating your name and, if relevant, the organisation that you represent each time before you speak. If you're not at a table with a microphone, then a roving microphone will be provided. So please wait for one, and these will be brought to you before you speak. Just a few words now about personal information. When speaking, do think carefully about your personal information. If you feel the need to refer to something which is personal or confidential, please bear in mind that anything that you do say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, if the process, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. A link to the Cabinet Office privacy notice was provided in the Regulation 32 letter, published on the 6th of February. I assume that everybody here has familiarised themselves with this document. If you have not, please speak with Mr. Randall if you have any questions. On to the purpose of the meeting today. This is the first ever examination under MEMA. The purpose of the preliminary meeting is to discuss the procedure of the examination of the application for a marine infrastructure consent, or MIC, for the Mooir Vannin generation project. The application has been made by Mooir Vannin Offshore Wind Farm Limited, who will be referred to as the applicant. The meeting will focus on the process of the examination only, and today we are not looking at the substance of the proposals. Questions, discussions, and representations about the merits or disadvantages of the application are for the examination itself. The examination will begin following the close of the preliminary meeting. This meeting provides the principal stakeholders with an opportunity to make representations about the process that we intend to follow. The meeting will follow the agenda published at Appendix A of the Regulation 32 letter, dated the 6th of February. The applicant has submitted a change request at procedural deadline B, which was the 24th of February 2026. We will cover the examining body's approach to considering and ultimately determining that change request in agenda item 4, which is on timetable. Now, turning to all of you present today, thank you very much for coming to participate in these proceedings. We have a list in front of us of the parties who've expressed an intention to speak at different agenda items. We will provide you with the opportunity to make your representation at an appropriate agenda item. With that said, I'm not intending to take introductions at this time. I will, however, check to confirm if there are any members of the press attending today. Are you intending to video record any part of the meeting today? Okay, no. Thank you very much. Okay, that concludes this agenda item. Moving on to agenda item 2, which is the examination process and principal stakeholders. We have published the examination guidance on the MEMA website on the 9th of February 2026. I will not repeat the comprehensive overview provided in that guidance and assume that everyone has read that document. There are a few points that do bear repeating though, and they are: the examination will commence after the close of this meeting. The examination must be completed in 130 working days and in line with the examination timetable. We will talk about our draft timetable later at this meeting and publish our final timetable as soon as practicable after the close of this meeting. The examination is primarily a written and inquisitorial in nature, which means that we will seek representations on matters that we consider relevant and important and that need testing. The testing will be evidence-based. For any matter or evidence to be considered, it must be entered into examination. After the close of the examination, we will have 60 working days to write a recommendation report and submit to the Council of Ministers. And subsequently, the Council of Ministers have 30 working days to make a decision. Now, just a few words, I want to touch briefly on the principal stakeholders identified by us. For the purpose of this examination, Section 2 of the examination guidance provides a good overview of the status and role of various parties identified under MEMA. And these are interested parties, relevant parties, and Section 23 notifiables. The examining body, for the purpose of this examination, has determined that all interested parties, all relevant parties, Section 23 notifiables, and all parties that responded to the public consultation will be considered principal stakeholders. Principal stakeholders will be regularly communicated with in respect of updates on the examination and are entitled to take part throughout. This is all I have to say under this agenda item, but I will turn to participants today. I have 2 persons who have registered to attend this meeting today who I believe would like to come forward to say something, to make a representation under this agenda item. I will take them in turn, and when I call your name, if you can come to the table in front to the microphone and make your representation. The first party that I have here is a person representing Burbo Extension, Walney IPS, and Wards Hold Company Limited. Is that person present today? Virtually. Good morning, Mr. Grigg. You should be able to turn your camera and your microphone on.
Thank you, Madam. I didn't specifically, to be honest, had anything necessarily under this agenda item. I had a few points to make procedurally I can make them now if you want. They're not massively earth-shattering points, but they're more by way of clarification.
No, this would be this would be a good agenda item to make your points.
Okay, that's fine. Thank you, Madam. Really, there's just a few points. One was in relation to notification to various parties. I think you've noted the parties that I represent, who are all existing operational wind farms potentially impacted by the development. I just wanted to make the point, Madam, that there's been a little bit of inconsistency in terms of notification to parties. Some of the existing wind farms have been notified of procedural arrangements and some haven't. So it was really just to make the point and request respectfully that all the existing wind farms are notified. I appreciate this process is an early stage, so there can be sort of early issues with these sorts of things, but it's just really for noting that, please. The second point was in relation to statements of common ground. There have been requests for statements of common ground for various offshore wind farms, but that hasn't included west of Duddon Sands, and it was again just perhaps to suggest that it might be helpful for your purposes if a statement of common ground was also concluded for west of Duddon Sands. I think particularly for that one, because as you may well be aware, there are two relevant parties who have interests at west of Duddon Sands, so it might be helpful for your perspective just to seek coordination of that and ensure that you have knowledge of the level of agreement between the applicant and the parties there. And then the final point, Madam, was just again just to clarify in relation to the timetable, whether there would be an opportunity to respond to the comments that the applicant has made on representations, perhaps at deadline 1. I appreciate that probably we get wrapped up in any event, I suspect, in relation to any written summary of oral representations for the hearings. But there might be points that parties want to pick up in response to what the applicant has said. So I just want to clarify whether there would be an opportunity to do so at deadline 1. So that's the 3 points, Madam.
Thank you, Mr. Greig. I will respond to these points exactly in the same order. So the first about the notification, thank you for letting us know that you've not been receiving these, but the good thing is that this can be resolved. And Mr. Randall, if I can leave that as an action for you to test the relevant email that you have for this party, and to ensure that those notifications are going through. The second point on statements of common ground with operational wind farms west of Duddon Sands, as noted in the Regulation 31 letter, which is Examination Library Reference PD 002, dated the 9th of February, the parties listed for the preparation of statements of common ground are not intended to be exhaustive. So the omission of any party from that initial list is not a reflection of us wanting to limit any wider engagement, especially where it's considered appropriate and relevant to the examination. So the applicant may choose to engage with other parties, and indeed other parties may come forward to engage with the applicant. Just a question to you, Mr. Greig. Have you been in touch with the applicant and requested a statement of common ground be prepared between yourselves and them?
Not as such, Madam, but we are due, I think, to have a discussion with the applicant, hopefully over the course of the next week or so. So that would be one of the matters that we might raise with them at that point.
Understood. On the third point, which is responding to comments from the applicant, there is, and each deadline is an opportunity to comment on what the applicant may have stated at the previous submission. But if it's okay for you to, if you're going to stay for the extent of the meeting, then this matter is better covered off in agenda item 4 under the timetable.
That's no problem. I'll be here throughout, madam.
That's excellent. Are there any further points from yourself, Mr. Greig?
No, that's it for now. Thank you.
Okay. Good. Okay, I will now move on to the other party who I'd like to invite, and that is Georgina O'Sullivan. Oh, would you like to come forward, Ms. Sullivan, to the table and make your representation now? That's fine. Are you intending to speak later on at the public meeting this evening? Okay, that's good. So it's good. We'll cover your points then. None of the other parties who've registered to speak, I believe, would be speaking at this agenda item. So unless there are any other questions, yes.
We seem to have had some confusion. The agendas have changed, and we didn't put in to speak on this one. But there is a.
Would you wait for the microphone, please, sir? I'll make sure that a roving microphone. And before you speak, if you could introduce yourself.
Yeah, Martin Royal, Clark, Garth Commissioners. There is one matter that the Commissioners would like to raise at this stage, and it is really to get it onto the public record, and it is perhaps not for you good people at the very front of us. It is more for our government, but I want it on public record. The Commissioners wish to note for the record that we were not formally included in the scoping arrangements, and it would appear that occurred because our own Department of Infrastructure decided that local authorities should not be party to that process. We were very disappointed by that. We only learned of that retrospectively. So I want that, or the Commission would like that to go down on the record, and it's a matter we'll take up with government at a future date. Secondly, and the better news is that we would really, since we were aware of that, we would like to note that the MEMA team themselves have been very proactive in allowing us to engage constructively in the process. So I want that to go down on record too. And also, quite ironic really, that I was given information that Orsted themselves, some time ago, had actually been in discussion with government and suggested that local authorities should have more of a role than had been prescribed by the government. So we thank them for that intervention, and we find that helpful. And as I say, apart from that initial negative, we feel positive about the process and wish to engage in it as constructively and positively as possible. And that's me. Thank you.
Thank you. If you could just, I think it'd be, first of all, just to acknowledge, thank you for your engagement. These points have been noted. There are a couple of things that I think I can respond to at this point. First of all, so the first point was that, so all of these points have been noted. In terms of engagement with local authorities, have you seen the Regulation 31 letter, which was issued on the 9th of January 2026?
I would probably say so. I think so if I'm in my head I've got the right document, but I've not got it here in front of me, so it's difficult to confirm that fully, but I think so if it's the one I'm thinking of.
Okay, so one of the items that have been requested in the Regulation 31 letter by the examining body is what's called a local authority effect statement.
Yes. Yeah.
We have requested that by the 31st of March, which is deadline 1 in our draft timetable. And that would be a way to engage with this examination. So while I cannot respond on behalf of the government, I can say that the engagement is being sought from local authorities. On other matters which do go a little bit into the merits of the scheme, we would ask you to stay engaged, as these matters are going to be raised at SIH2 on some of the methodology of doing the environmental assessment, and so more detailed commentary on that point will be welcome at SIH2, which is on Thursday, the 5th of March.
We've registered for that, so we will engage very positively in that. And also, my point was that the commissioners feel that we would have added to the process, and it would be better for public transparency that the commissioners were involved, or that local authorities in general are involved in these kinds of processes at the earliest stage possible. That is generally in the public interest, we would say.
Fine.
Okay. But that's not, obviously that's not to do with you guys there.
Yeah. Mr. Royal, don't go yet, because two of my colleagues have expressed an interest to say something. So if I could hand over to Ms. Fernandez first.
Just very briefly, we know that we're hearing again from your colleagues this afternoon at the public meeting. I think several of your colleagues are coming along to talk to us in more detail, and we look forward to hearing from them.
Good, thank you.
And briefly, if I could make an observation, one of the things that we obviously have to do when we're preparing for an examination, being very conscious this is the first examination of this type to be conducted in the Isle of Man, is to think about the best and fairest procedure that we can bring forward. And certainly in the early pre-examination stage, we gave very careful consideration to how best to involve local authorities on the island, recognising that the role of local authorities here are very specific to the Isle of Man, and so in conversation with Cabinet Office framed the process of seeking the local authority effects statement, the LAES, which is explained in the letter that Ms. Sahai referred to. There is also guidance on the LAES that's available on the MEMA website, so I would just briefly like to flag that's there too.
We're fully ready to engage with that.
Wonderful. Well, I very much hope that in the spirit of that guidance, we hear you fully moving forward.
Okay. Could I, sorry, you've provoked a question in me. You say you were involved with that process earlier.
Yes.
When did that occur? When was that
At the point of our initial appointment, at that point, we start to sit down and think about essentially all of the matters that are brought forward in our proposal to examine the application that we're now testing in this meeting today. So ever since we were appointed, we have been thinking very carefully, how would we design a fair examination and what should it consist of? And as part of that conversation, part of that process between ourselves, we thought about the role of local government, and we determined that we would A, seek that specific involvement, and B, provide some guidance to help that process be brought forward.
No, that's fine. You've clarified it was after you were appointed.
Yes, it was after our...
The conversation I referred to that the Department of Infrastructure had with, I presume, MEMA at the time, or some bodies was much before then.
Yes, I can make no comment about that. Sure. All that we can refer you to, sir, is the conversation that we, as an examining body, have had about the way that we structure our own processes, which we obviously do with the greatest of care, having regard to all of the principal stakeholders' needs.
No, that's excellent, thank you. Is that me done, ma'am? Yeah.
Yes, thank you very much for your representation. Ms. Pownell, was your comment quite specifically to Mr. Royal, or? Okay, my point.
It was just that you registered to speak on the initial assessment of principal issues. I wondered if you just wanted to stay seated and still make that representation, or whether you wanted to leave that.
Sorry, I do have not great
No,
hearing,
that's okay. So. You registered to speak at item 3, the agenda item 3, on the initial assessment of principal issues.
Yes.
I wondered if you wanted to remain seated, if you wanted to still make that representation. That was all I wanted to add.
Right. The agenda has slightly shifted since the one I've seen.
No,
I think on the new agenda we would need to speak at the point... Have we got the agenda? As you say, item 3. Yeah. Sorry.
I just wanted to save you moving backwards and forwards. You wanted to stay seated.
Okay. Thank you.
Since we've been informed that there has been some confusion about the agenda is actually on the screen now. And before I move on, I do want to just check if anybody else wishes to speak on agenda item 2, which was the examination process and our approach to the identification of principal stakeholders. The applicant wishes to speak. If you could introduce yourself, please.
Yes, my name is Amy Sterling. I'm a Senior Associate Solicitor at Pinsent Masons and I'll be representing the applicant today. I just want to check that... Yeah. The mic's not on. Is the mic now working? Yeah, great. I think it's on now. Sorry. Yes. Hi everyone, my name is Amy Sterling. I'm a Senior Associate Solicitor at Pinsent Masons and I'll be representing the applicant today. I just wanted to respond to the point raised by Mr Gregg on the relation to the Burpo extension, Walney and West of Duddon Sands. Firstly, the applicant's happy to engage with West of Duddon Sands to produce a draft statement of common ground and will endeavour to do that for deadline 1. We would also welcome responses to the consultation responses that we submitted for procedural deadline A at deadline 1 as well. The only observation I would make is that Mr Gregg didn't introduce himself, so I'm not actually sure. I presume he's a solicitor and I presume he's representing the 3 parties, but I don't know. I think it would be helpful for the record if he was able to introduce himself, at the very least, so I know who the correct person to contact is.
Mr. Gregg, I think what Ms. Sterling is asking for is your role, perhaps, because you did introduce yourself by name and the parties you're representing. But if you could tell us what your role is.
Michael Gregg. I'm a legal director with DLA Piper Solicitors, representing Burpo Extension, Walney UK Offshore Wind Farm Limited and Walney Extension, and also Orsted Schroders Greencoat Wads Holdco Limited. So I hope that clarifies.
Is that clear, Ms. Sterling?
Amy Sterling on behalf of the applicant. Yes, that's clear. Thank you.
Okay. Were there any further points from the applicant?
Amy Sterling on behalf of the applicant, no further comments.
No, okay. So, and we welcome your willingness to engage with Mr. Gregg and those parties. So that's very helpful. Any further points on agenda item 2 before we move on to agenda item 3? I'm looking around the room, and if I could just have a quick sight of the virtual room, please, Mr. Randall. Nope, there are no hands up. Good. I will hand over to Ms. Pownell now to talk us through agenda item 3.
So, the examining body published its initial assessment of principal issues, which can be found at Annex B of the invitation letter under Regulation 32(2). The initial assessment was prepared by the panel following our reading of the application documents, public consultation responses, and consideration of any other important and relevant matters. The initial assessment has guided the examining body in forming a provisional view of the application that's to be examined. It's not comprehensive or an exclusive list of issues that will be examined, and inevitably there will be some issues that overlap or interrelate. It's based on our reading of the application documents, representations received, and an initial consideration of important and relevant matters. It should be clear it doesn't determine the full scope of the examination, and it will inevitably be the case that other relevant issues will arise throughout the course of the examination, and those other issues will also be considered and examined. And equally, issues currently on the list, which should be behind me, yes, issues currently on the list turn out not to be as important as we first thought. The examining body will have regard to all important and relevant matters during the examination and when it writes its recommendation report to the Council of Ministers after the examination is concluded. The order of issues listed in the assessment do not imply any order of prioritisation or importance. They're all treated equally. It should be noted that whilst human rights and equalities duties are not listed as main issues, all aspects of the examination will be conducted with these in mind. So we had one request from Martin Royal from Garth Commissioners to speak to this agenda item. Before inviting Mr. Royal, is there anyone else that would like to speak? Please remember that we're not here today at this particular session to discuss the detailed merits of the application or specific issues, only the principal scope of the examination, the broad high-level scope. There will be opportunities for all parties to make these submissions as part of the detailed examination on the application, which, as Manika says, commences after the preliminary meeting with the public hearing. I note that several people have registered to speak this morning and are also registered to speak this evening, when we will be hearing about the merits of the scheme. So with that in mind, is there anyone that wishes to speak? Sorry, what's your name, sir? Can we get the mic to the gentleman in the middle?
Are we good? Hello, can you hear me okay?
Yeah.
Okay, thank you. Good morning and thank you for the opportunity to speak. My name's Ian Strafford and I'm a resident of the Isle of Man.
If you just register your name with me, if you'd like to come forward to speak at the agenda item, please. If you'd like to come forward to the table, and then I'll come to you at the end. Mr. Royal, if you'd like to stay seated.
Oh.
And you can go first, Mr. Stratford.
Yeah, there you go, Ian.
That's great, thank you. Okay. So, Mr. Royal, if you'd like to speak first, would that be all right?
Right. In terms of this, we just want to raise extremely briefly some matters in regard to the environmental assessments and so on. The first one, I think the bottom line, I'm saying it quite plainly, is please could the examining board weigh the wisdom of putting such a large array right bang by a very small landmass. I think, let's talk about the UK. I think it's a very different situation here than in the UK because we have that small landmass. So that's one issue that I would like to be explored later, which we will come back to. The second item is the importance of the landscape character assessment document that was published by our government last year, which, because of timing, couldn't be included in the applicant's environmental assessments. However, that document, we believe as the Commissioners, is absolutely key to a fair and appropriate judgment of the proposal. So, to be short, we would like the examining body to include that as a document that it relies upon and takes reference to. The third item we would like the examining board to look at are the consequences for the economic future of the island. Now, under MEMA, there are some very vague references to making sure that it's in the public interest and so on. I forget the wording, but we would like that aspect to be weighed by the examining board. However, that is against the context where our investigations with our government have given us indication that unfortunately not many of our MHKs or many people in our government seem to have a grasp of the economic consequences of the project on the island. So as far as the examination board is able to, please could they look at that, because at the moment our government would appear to be failing us as a nation. And the final thing, is to do with the uniquely Manx approach. Now, I'm not going to say much about that, although there is much to be said later, but I would just like to stress for the examining board that the Isle of Man has been independent for many, many years, thousands of years. It is its own nation. It is not a separate county of the United Kingdom or Ireland, and we would really appreciate that that is taken into account, that I suppose, we do things differently here, and our people are different, although we enjoy wonderful ties with adjacent jurisdictions. So the plea is, please, can that be noted, that this is an independent nation and has its own culture, its own systems that we're very proud of. To digress, if you don't mind, this nation was the first by many decades to give the franchise to women. It beat the UK by 40 years or so. And more recently, we have become the first of these jurisdictions in this part of the world to introduce an assisted dying bill. We make our own rules and we act independently. So please, can that be borne in mind as you consider this application?
Thank you, Mr. Royal.
Thank you.
Thank you. Your points have been noted and will form part of the examination.
Thank you.
Mr. Strafford.
Hi, good morning, and thank you very much for the opportunity to speak. Martin's covered a number of the points that I did want to make, but I think I'd just like to add one final bit for the examination, if I may. A lot of benefits have been purported from this project as far as the Isle of Man is concerned, with respect to resilience to power, net zero, big financial benefits, etc., etc. It should be recognised that the key beneficiary of this project will be the United Kingdom with respect to power. And indeed, at the moment, as we stand today, it's a work in progress, if I can call it that, as to whether any of that power would come to the Isle of Man at all. There is work that has been done, and the Isle of Man government commissioned it back in 2023 through ARUP, which looked at the alternative approaches for the Isle of Man and what scenarios it would consider to get to a net zero position in clean energy by 2030, as required under the Climate Change Act of 2021. At no point has this project been considered in the round with respect to those other alternatives from an Isle of Man perspective. So in terms of truly assessing benefits and disbenefits, when we recognise that this project does have a number of disbenefits to the Isle of Man, I would request that it is put in the context and that those other scenarios are considered as part of weighing the benefits and disbenefits of this project.
Thank you, Mr. Stratford. Thank you.
Okay.
Your points have been noted. Thank you.
Thank
Is
you.
there anyone else that would like to speak? Yeah.
Yes, my name is Amy Sterling. I'm a Senior Associate Solicitor at Pinsent Masons on behalf of the applicant, dealing just with the procedural points, which is for the purpose of this hearing, to confirm that the applicant is updating its environmental impact assessment to address the landscape character assessment that was published after submission, and that will be submitted at deadline 1 of the examination. Also to confirm that the applicant's planning support statement is not based on helping the Isle of Man achieve net zero, and the applicant will be updating its planning support statement as requested by the examining body at deadline 1 as well, to make entirely clear its planning support basis. And then the final request for Mr Strafford is if he could, in his oral submission note, provide a reference for the ARUP report from 2023 so that we can review that document. Please. Thank you.
Mr. Stafford, as we've stated before, for anything to be considered in this examination, we will need it to be submitted into the examination. So if you do make reference to something, I would request you to actually submit it at an appropriate deadline. So we'll make that request as we go. But on this particular occasion, if there is a report that you're relying on and would like the examining body to take account of, then do submit it into the examination. It would be at an appropriate deadline, so perhaps at deadline 1. And what I would say is that if you speak to the case manager, Mr. Randall, he will advise you on the best way to do that. Good. If there are no further matters on agenda item 3, initial assessment of principal issues, then I'm just going to wait to see a show of hands in the room. Nobody. If I could just have sight of the virtual room, please, Mr. Randall. Nobody here as well. Good. We'll move on to agenda item 4, please, the timetable, and I'll hand over to Mr. Smith.
Thank you very much, Ms. Sahai. Now, as Ms. Sahai has remarked, the examining body is under a duty to complete the examination of this application by the end of a period of 130 working days, beginning with the preliminary meeting's closure. And to ensure that we do so successfully and in a fair and orderly manner for all, we have prepared a draft timetable to govern the examination process. And the invitation letter that you received to this meeting included Annex C. That's the Regulation 32.2 letter. It included Annex C, which provided a draft timetable setting out important deadlines for the receipt of representations and other information, and reserving dates for hearings and meetings during the examination period. Now, the examination is primarily a written process. It takes the form of the consideration of written submissions, and the draft timetable's main job is to set the dates for these to be made. I will draw your attention to the fact that we ask for particular documents to serve particular purposes on particular dates, and that the latest time for submission of documents on those deadline dates is 23:59, the minute before midnight, on the relevant date, unless instructed or agreed otherwise. And I think it's important to labour this point a little, because late submissions are only accepted then at the discretion of the examining body. And that includes submissions where principally the timetable provides that it should be submitted at, say, deadline 1, but somebody thinks in their own wisdom that they would prefer to submit it at deadline 2 or deadline 3. That would amount to a late submission, and so it would become then something that would only be accepted at our discretion. And I emphasise the importance of that point, because in courtesy and fairness to all participants in this process, we need to make sure that we are reading the right information at the right time. Everybody participating in this examination needs to be aware of everything that they need to think about before, for example, they make their own responses, typically at the following deadline. So if any individual is late, it doesn't only affect them, it affects us all. It affects the examining body's ability to synthesise all of the issues in our own minds, but also it affects all of the principal stakeholders' ability to actually consider what others are saying and consider whether they need to respond. So there's a really important fairness point here. If any documents are submitted late for any deadline, or at a subsequent to the anticipated deadline, or in any disorderly manner outside the deadline structure, then the effect of that is to reduce or exclude the ability of participants in the examination to consider and respond to all of the information properly. The examination loses focus on what is relevant and important, and these effects are not fair or appropriate, and they do not support the making by us of a sound recommendation. And so for these reasons, I do need to emphasise that we will be both firm but fair. And so I'm placing everybody on notice that we will not normally accept documents outside the deadline structure in the timetable unless there is a very clear reason provided to us which explains to us why we ought to do so. and only in those circumstances where the reason is cogent and in the public interest would we accept late submissions and then bring a late or unexpected document into the examination. Now, is that general point clear for everybody in the room? If anybody's got any questions about how that works, or the underlying principle of fairness, then do let me know. And can I just check the virtual room to see if there are any hands raised? And there are not. Thank you very much. So, I'm now going to talk about the principal components of the timetable. It makes arrangements for public meetings and hearings. Public meetings are places where a person wishing to speak about the proposed development can attend and have their say, broadly on matters of their own choosing. In the interests of fairness, we will always set agendas for public meetings to ensure that people who have registered to speak know when they are going to speak and how long they have. And so for this reason, if you do wish to speak at a public meeting, we really do urge upon you the value of registering in advance. And the timetable does include deadlines for registration in advance for the public meetings that will take place later on in this examination. The timetable, by seeking registration in advance, helps us to run the best events that we can for all of us. And these work best if we know in advance who wants to speak. I'm now going to speak briefly about the provision for specific issue hearings in the timetable. Specific issue hearings are places where the examiners set the topic of the discussion that will be held to explore the effects of the proposed development. We set the discussion topics in agendas, again, which we publish before the events, and we select the topics because they are likely to be relevant and important to our final recommendation, and typically because the matters at issue are complex, affect multiple parties, and maybe in some respect are in dispute. By gathering all of the relevant parties around a table, we aim to understand the complex issues in the examination as best we can. And there is a particular efficiency in a hearing being held where all of the people whose submissions are relevant are in the same room together, and therefore we can shortcut the need for multiple rounds of written questions. Agreements can be reached where agreements are possible to be reached, or alternatively we can cut swiftly to the chase and understand the scope of disagreement between parties and the matters that we will need to make recommendations upon. The timetable sets dates for expressing interest in and attending hearings. But please note that we may invite parties to specific issue hearings even if they have not specifically already registered or requested to be heard. And we will do this where we feel that their information needs to be considered alongside that of other parties in order to help us to resolve a complex issue on which we need to make a recommendation. And the reason that I'm raising this point now is to make clear to all prospective participants in hearing processes moving forward that if we do invite an attendance in circumstances where somebody has not requested to be heard, we will have a very good reason for doing so, and we will be extraordinarily grateful for attention to that invitation and the offer to attend. People can attend virtually as well as in person. We've set agendas for our first 3 specific issue hearings and a public meeting that are going to be held this week. I will flag that we have not yet done this process for any later hearings or meetings that we may hold in May and July. In the draft timetable, we've reserved time when these hearings or meetings might proceed, but do note that if it turns out that a particular hearing is not required, a particular event is not required because the written process is resolving matters, we're not going to hold hearings for the sake of holding hearings. We will only hold those hearings if there are outstanding matters that need to be discussed. Once it's clear that hearings and meetings are likely to be required in the May and or July time periods, then we will provide written notice of the matters to be discussed, and we will provide agendas before meetings or hearings that are equivalent to the agendas that you will have seen for this week's events. Okay, does anybody want to raise any questions or speak at all about the principles which underlie the design of the draft timetable, the approach to written deadlines, and also the way in which it structures meetings or hearings? Madam, would you like to come forward, please, and take a seat and introduce yourself?
Marinda Farragut speaking as the Vice Chairman of Golf Commissioners. I'd be interested to accompany you on some site visits when you come back to the island. So when you said then, sir, that might vary, at the moment I put it in my diary, I think, for July, was it the May or July? So if that, when will I know if that changes?
I think in principle, unless anybody were to substantially object to that July window that we've identified in the draft timetable as being the time when we ought to hold those inspections, and you'll be very conscious that weather is a consideration here, and we chose July as a target time because we felt that it would give us the best likelihood of an undisrupted ability to conduct inspections. So unless anybody's objecting and thinks that's the wrong time to do that job, my feeling is that we would be very likely to confirm that window. And I will also indicate that at the next agenda item in this meeting, we're going to cover some procedural directions that we will give on special procedures. And actually one of those items is the making of arrangements for site inspections, including the ability of principal stakeholders to make nominations about where we might consider we go. So Ms. Fernandez will be covering that very, very shortly.
Thank you.
Thank you very much. Unless there are any other observations on timetabling arrangements, I just want to speak briefly now about flexibility in the examination timetable. Because from the tenor of my remarks in opening this item, you'll have seen a view that we need to maintain order and fair process in the examination throughout. So once the timetable is approved, which we aim to do as soon as practicable after this meeting, taking into account the points that have been raised, we will all be doing our best to adhere to it. And it's important that the timetable doesn't jump around, it shouldn't change from week to week. And in that regard, if we do need to change the timetable for any unforeseen reason currently, then we will give you the best possible written notice that we can of that. Now, I do want to specifically flag that the applicant has already sought our consideration of a proposed change to the application under examination document library references PDB 001 to 017. By the way, that's the first time you'll have heard that sort of language in this examination process. We publish on the website an examination library of all the documents that are put into the examination. They are all given a unique reference number so that we can't get them lost. And moving forward, whenever we're talking about the documents that we refer to, we will always cite the reference numbers in the library, and I'd be very, very grateful if everybody could also do the same. So those are the reference numbers for documents that the applicant has provided to us seeking a change to the application. We will need to consider whether that is a change that can lawfully be made, because we need to satisfy ourselves under MEMA that it is not a material change to the application in front of us, which would essentially mean it was changing the proposal from the current proposal into a different proposal. So we need to make that consideration first. If we take the view that it is an acceptable non-material change, then we will need to consult the parties on its effects, and if we are required to do that, then we would make arrangements to do so within the framework of the existing timetable as far as is possible for that to be achieved. As of today, however, I must be clear that we consider that there are likely to be some questions that we will need to ask the applicant before we resolve precisely how to manage that request in timetabling terms. We will discuss the applicant's proposed change further in specific issue hearing 2, and my colleague Ms. Fernandez will have some questions that she wishes to put at that point. And what we will then do is we will determine whether or not we need further information, and if we do, we will make a request for that information from the applicant under Regulation 31.9, and we will seek it. Once we have that information to hand, we will then consider the timetabling implications of the change request that has been sought. Does the applicant wish to address me on that point at all before we move on? Because I do have one more general remark about the possibility of further changes.
Amy Sterling, on behalf of the applicant, no, your position is noted.
Okay, thank you very much, Ms. Sterling. Now, it is not impossible that discussions in the examination process might lead to further change requests. And I sort of explain that in these terms. Productively, in an examination period, an applicant will normally try to address relevant and important issues that arise during the application where they can do so. And from a standpoint of many years' experience examining projects such as this one, noting that the Marine Infrastructure Management Act of 2016 does set a hard deadline for the end of this examination, and that equivalent examinations in the UK conducted since 2012 have all met their statutory end dates, we will be really working very hard to achieve that, the formal statutory end date here. So bearing that in mind, we've then got to think about when in our timetable the applicant might need to have requested any changes in order to ensure that they can be fully and fairly considered and duly examined before we close. Now, if we look at that indicatively, we do have to take into account that there are elections on the Isle of Man, and Tynwald is due to close in July. And so we have to be careful about loading substantial activities into the tail end of the examination. Depending on advice that we receive on that point, if we had a view that something was highly controversial and it would be difficult to examine in the tail end of the examination, then changes are likely to need to be submitted no later than deadline 2, currently the 14th of April, in order to provide full opportunities to comment and, if necessary, for matters to be brought to a hearing before the end of the examination. For matters that are of a more, I guess, minor and less controversial nature, then potentially we could entertain change up to as late as deadline 5. However, I think it's important to observe for the applicant's benefit that if significant change were to be brought in after that point, there simply would not be enough examination process time left, irrespective of election considerations, to enable a full and fair examination of changes that were brought forward. And I thought it was important to place us all on notice of that. Now, we are not inviting changes, but I think that it's important that if any changes do need to emerge as a consequence of discussions, negotiations, or hearing processes and the like, that the earlier in the examination they are documented and requested, the better, and more broadly, the more fully they are documented, the better, because what we also wish to avoid is a circumstance where a change emerges, we then need further information, so there is further delay, that information is then produced, and that in turn knocks consideration of the issues further into the tail end of the examination. So, as early as possible, and as full an explanation as possible for any changes that the applicant might seek, please. Now again, I'll go to the applicant first. Any further observations on that, Ms. Sterling?
Amy Sterling on behalf of the applicant, the examining body's position and the relevant deadlines are noted. No further comments.
Okay, thank you very much, Ms. Sterling. And I'm just checking with the floor, and indeed, can I just check with the virtual room? And I'm seeing no hands. Now, before I finally close out timetabling matters, I did note Mr. Grieg for Walney Extension was wishing to ask for a specific opportunity at deadline 1 to comment on the applicant's responses that have already been received and published. Mr. Grieg, is there anything, is my characterisation of your request clear enough, or is there something else you need to add? By the way, am I pronouncing your name correctly, sir?
Unfortunately not, sir. It's Greg.
Greg, apologies.
So because it's EIG as opposed to IEG, so not like the musician, I'm afraid. But yes, your summary of the position is correct.
Okay. Well, we will certainly consider making a minor adjustment to the timetable to deal with that point, Mr. Gregg.
Obliged, sir.
Okay. On that basis, whilst I have a full copy of the draft timetable in front of me, I'm then going to just finally ask, does anybody wish to make any final observations on the draft timetable? Ms. Sterling, for the applicant.
Amy Sterling on behalf of the applicant. I've already made our submissions on Mr Gregg's request. We're happy for him to respond to the consultation responses at deadline 1. Of course, to prevent sort of continual toing and froing, we will also seek to capture the latest position in the statement of common ground, which might be a more efficient way of tracking negotiations between the various parties. I did have some updates in relation to examination deliverables, which are due at each deadline, if this is the appropriate place to speak to them.
Absolutely.
Great. First, in relation to statements of common ground, the applicant is proposing some additional statements of common ground from those which have been requested by the examining body. The applicant will be submitting draft statements of common ground with the Department for Enterprise, with Manx National Heritage and with Manx Utilities at deadline 1. We believe that these will be beneficial for the examination of the relevant matters before you. Also to confirm that we will not be progressing a statement of common ground with Natural England. You will see their response to procedural deadline A confirming that they will not participate in the examination of the application. The applicant also does not propose to prepare a statement of common ground with the Recreational Fish Management Board, who were listed as a party in the list of statements of common ground, because the applicant considers that this is best captured within the statement of common ground with Manx Fish Producers Organisation, and a draft of that statement of common ground will be submitted at deadline 1. Turning then to some additional deliverables that the applicant wishes the examining body to be aware of. I am sure we will discuss this in more detail tomorrow. However, the applicant is preparing a funding statement which will set out the applicant's position on the funding of the construction, operation and decommissioning of the proposed development, and will be submitting that at deadline 1. The applicant is also preparing a land rights tracker along with a relevant plan which will identify the relevant land parcels and provide an update on the status of negotiations with the various land interests. Again, that will be submitted at deadline 1. And then the next
Can I just arrest you a second, Ms. Sterling, because my colleague, Ms. Sahai, has a question on that point.
Sure.
Ms. Sterling, these are all very helpful points, and I know that it's not always possible to give us an indication of the points that you're going to make at hearings in advance, but it would have been helpful to have an overview, as we had requested in the registration process, of the points you're going to make and at which agenda item. Having said that, all of these updates are incredibly helpful, and we will require them in writing for you to be submitted as well so that we can consider them. We will not have enough time to do that this time, but we will do our very best for SIH 1 because a lot of these matters are relevant. But the changes that you, or the points or the updates that you are requesting be included in the timetable, we will request them in writing. And in future, if you can, make sure that you let us know in advance when you're registering of who's going to speak and at which agenda item. That would be enormously helpful.
Amy Sterling on behalf of the applicant. Points noted and taken. These have arisen on receipt of your detailed agendas and in preparation for specific issue hearing tomorrow. I didn't want to sort of blindside the examining body tomorrow by referring to documents that I haven't let you know in advance that those would be submitted. So the final point that I have on my list, and again we can speak to more detail on this tomorrow, is that the applicant will be updating the draft marine infrastructure consent to include protective provisions for utility and telecoms undertakers at the next relevant deadline as well. I look forward to discussing in more detail under the appropriate agenda items tomorrow.
Thank you very much, then, Ms. Sterling. Can I just then check the room, and I also want to check the virtual room. Can I see hands from those people who wish to speak? I am going to go to Mr. Brooks first, and then, sir, can you come forward, please? And I will come to you as soon as I've heard Mr. Brooks. Just checking the virtual room, I see no hands. So, Mr. Brooks, if you can introduce yourself.
Thank you. My name is Ian Brooks. I am the Legislation and Policy Officer within the DOI, but I'm also a Chartered Town Planner as well. The point that I just want to bring to the attention to the examining body is in relation to deadline 6. Particularly, that particular deadline falls on Monday, the 6th of July, 2026. That is a Tynwald Day, which is a public holiday within the Isle of Man. Obviously, that has a bearing in terms of submission and also the timetabling for the examination as well, because it's not classed as a working day for the purpose of MEMA.
Yes. Yeah. No, and apologies. I mean, you know, one of the things that I'm acutely conscious of is our standing as folk who are not normally resident on the Isle of Man, and the critical importance of us observing the Isle of Man's cultural and legislative differences. We had actually kind of absorbed that in the gap between the draft timetable and now. So there will be, and I'll make this point generally without labouring them all individually. There are probably about 5 or 6 sort of minor typographicals in the timetable that we will need to change and to reflect the things that we are able to properly do. That was one of them. Thank you for raising it, and we will make sure it's fixed before the final timetable emerges. Any other observations, Mr. Brooks? Okay, thank you very, very much. Sir, your name?
David Beard. I'm from the Manx Fish Producers Organisation. Sorry?
Thank you very much. Speak
Yeah,
away.
it was just in response to Ms. Sterling's statement just now about statement of common ground. I think, if I heard you right, you referred to recreational fisheries. Is that right? Did you refer to that?
Amy Sterling on behalf of the applicant. Yes, the examining body have asked us to prepare a statement of common ground with the Recreational Fish Management Board as the body who is listed in the Regulation 31 letter that was issued, and we're suggesting that a statement of common ground with that body isn't required, and that the applicant is progressing a statement of common ground with yourselves.
We don't represent recreational fishermen.
Can I just interject briefly, sir? When putting a question in these proceedings, always route them through the examining body. Yeah, put your point to us, and then if it needs to return to Ms. Sterling, then we'll return it to Ms. Sterling.
Well, if it's just to clarify, the Manx Fish Producers Organisation represents commercial fishermen. It doesn't represent recreational fishermen. So if the reference was that the statement of common ground would be to do with recreational fishing, then we can't be party to that.
Thank you very much for that point. In a nutshell, we need to consider as a matter, once this meeting is closed, whether or not we consider it's necessary to have a statement of common ground at all on recreational fishing, given the extent of public consultation responses on that particular matter that we have had. We will consider that, and we will either resolve that we do, in which case we will target that to the right organisation and not yourselves, sir, or alternatively, critically, we don't, in which case we won't be asking for one. Is that sufficient to make everybody happy on that point?
Thank you.
Have we got a hand? Yes. Madam, would you please come forward, or alternatively, if it's a quick point, if somebody could bring the roving mic. Now, Now take a seat and make yourselves comfortable, and then introduce yourselves.
I'm Patricia Newton. I'm a resident of Garth, and at my lot this is a largely retired town planner. A brief question. Have the panel, you talk about deadlines for documents, are the panel aware of DEFRA's intention to produce a marine spatial plan this year? And if so, how will this be tied in to this Commission's considerations? I've no idea if we've got a representative of DEFRA with us to clarify what the status of their proposals for this plan are.
Well, thank you very much. That's a very... Oh, can we just... Thank you. Do you mind moving your papers, madam? Sometimes quite hard to control the system if the microphone's covered up. That's a very, very useful insight. One of the things that we are in the process of finalising is our written questions to a broad range of principal stakeholders. And I think we will have to give consideration to whether or not we ask a written question about the existence, preparation and timing of the Marine Spatial Plan. Thank you very much, madam. Now, can I check, do we have any further questions on timetabling points, deadlines, provisions for public meetings or hearings? And if we do not, what I will then finally observe is that given the nature of the conversation we've had in the room today, I think it's fair to say that the broad principles of timetabling are understood and supported by the room, and that there have been no requests for major changes. We've heard one or two requests for minor and typographical changes, and we will ensure that those are properly finalised and made before we issue a final timetable. What issues will generally accord with the draft that you've seen, but we do reserve our right to make those final refinements necessary to make it into the best timetable we possibly can. But the one thing you can rest assured of is that all of the proposed examination events that we're then looking at moving forward will proceed in broadly the time blocks we've outlined, and the duration of the examination and the matters to be covered at the relevant stages of it are unlikely to change. So unless there's anything else that anybody wishes to say, this matter is now concluded, and I will hand over for agenda item 5.
Thank you very much, Mr. Smith. Okay, so agenda item 5 looks at what we call procedural directions. And for those of you not so familiar, a procedural direction is a specific direction issued by the examining body to the applicant and or principal stakeholders about the procedure to be followed for the conduct of the examination. And it can include things like submission and timing of evidence, conduct of hearings and meetings, and requests for further information. So we have heard already today about some of the procedural directions relating to the initial assessment of principal issues and the timetable. And now we'd like to discuss 5 more procedural directions today, and these relate to a variety of matters, one about artificial intelligence, another about accompanied site inspections, and then 3 others which relate mainly to document management and document control. So let me take the procedural direction about artificial intelligence. So the examining body understands the benefits that artificial intelligence can bring to planning decision making when it's used ethically and transparently. Where any participants in the examination are using generative AI, and here we're thinking about Microsoft Copilot, ChatGPT, Perplexity, Claude, anything like that, to create or edit any part of a submission, including text, images, tables, or graphs, it's really important to let us know. You don't need to include the use of basic spell checks, grammar tools, or use of search engines like Google, Bing, DuckDuckGo, although the use of or copying of text from AI summarization should be disclosed. All parties are asked to specify which AI systems they are using and the tools and what it has been used for, the sources of the information that the AI system has based its content on, and what parts of the submitted information or representation AI has been used to create or alter. If you are using AI systems to summarize, substantially rewrite, or add commentary to information which goes beyond a simple factual description, this can affect the accuracy and the interpretation of the underlying data. AI is known to hallucinate occasionally, providing plausible but erroneous, non-existent information and references. So please, if you are using AI, do let us know. In addition to telling us that you have used AI, as with all other information submitted to us, it is your responsibility to ensure it is accurate, fit for purpose, complete, and not misleading. You must warrant that a human has read all of the material before submission and agreed to its completeness and accuracy of any content generated or used by an AI system. And by following this guidance, the examining body can then understand the origin and the accuracy of the information and supporting our fair and impartial examination of this application. If it is found that you do not declare the use of AI in any submission where it has been used, or that you have removed or reduced evidence of its use, such as watermarks, links, citations, we reserve the right to reject your submission. Turning to accompanied site inspections, which I know we touched upon briefly earlier, the examining body under Section 30 of the MEMA has determined that part of the examination of the application should be conducted otherwise than by written representations. The otherwise, in this case, being accompanied site inspections. And some of you will have seen from the examination library that we have already undertaken various unaccompanied site inspections in October last year and also in January. And if you want to see where we went and what we looked at, have a look in the examination library at document reference EV001. That's EV001. And that will be a rolling document, and so when we make unaccompanied site inspections, we will keep it up to date. So today, we are making a procedural direction under Regulation 31(9) to include dates for accompanied site inspections set out in the draft timetable, as we discussed earlier, between the 13th and 17th of July. What we would ask you to do is to submit suggested locations for the XB to visit as part of any accompanied site inspection by deadline 1. And we would also ask that you include within this sufficient information to identify the location, obviously, it's quite helpful, the matters to be observed at the location, information on whether the site can be accessed via public land or is private and therefore would require permission and accompaniment by the owner or land or occupier of the land. Anything about information required to ensure we can visit the site safely, and the reason why you have suggested that location. And for those of you that are not familiar about accompanied site inspections, they are not an opportunity to make oral representations to the examining body about the merits of the proposed development. But you can indicate specific features or locations of relevance to the examination. We're asking the applicant, please, to prepare a draft itinerary for the accompanied site inspection to be submitted by deadline 2. and this should include relevant locations referred to in the consultation responses, locations of which the applicant has predicted likely significant environmental effects, and relevant locations submitted by parties at deadline 1.
There's a hand up in the audience.
Oops.
There's a hand up in the audience.
I will take questions at the end of this item, if I may. Comments by interested parties on the applicant's draft itinerary for the accompanied site inspections must be submitted by deadline 3. And just for your own understanding, the order limits for the application cover land and sea. There is unlikely to be sufficient time for us to, in the examination, to visit all sites which are suggested. And we have already obviously viewed quite a large number in our unaccompanied site inspections prior to this preliminary meeting. The XB will consider each suggested site location which has not already been visited and decide whether it would assist the examination of the application to visit that location. The XB will determine if it could be viewed unaccompanied from public land or on an access required basis, and whether it's necessary to visit that on an accompanied basis. And we will publish our final itinerary for the accompanied site inspection on the 26th of June 2026. And now there's a gentleman that had his hand up. If you'd like to come forward and introduce yourself, and I'm assuming you're talking specifically about accompanied site inspections.
Jamie Smith, Garth Commissioner. Very quick point. I hope it would be appropriate that a time of day could be specified as well. For example, some sites might, within reason, have a clear dark night as well as a daytime visit. Is that reasonable?
Yes, indeed. That would be extremely helpful to us. Thank you. And then I mentioned that I would be sharing with you 3 procedural decisions, directions in relation to document management that the examining body has made. So the first one is very much for the applicant, and it relates to the applicant's guide to the application. At each deadline, the XB would like the applicant to provide both a clean and a tracked change version of a guide to the application. And this should include a full list of application documents submitted to date and the revision history, presenting this information in a tabular format. The guide to the application should be a living document during the examination, capturing all updates and revisions to application documents in a manner that is easy for us to follow and for other IPs. Documents should be colour-coded, greying out those documents that have been superseded. The table should include the Vannin examination library reference and the deadline at which the document was submitted. It should also include the electronic file name, as that assists all readers to locate the documents. And ideally, the name of the document in a header or a footer. The second related procedural direction about documents is clean and tracked change versions of documents. And this is for all of you submitting updates to documents. Please can we request that the applicant and principal stakeholders provide both clean and tracked change versions of documents each time the documents are updated and revised for submission at different deadlines. The track change document must also include a tabulated schedule of changes. And again, that really helps people to follow the different documents that are submitted into the examination. And the last procedural direction in relation to document management is again for the applicant. We would request you to provide both clean and tracked change versions of the draft marine infrastructure consent at deadlines 4 and 7. And each time a revised version of the marine infrastructure consent is submitted, please can you make sure that the track change version has colour-coded changes. Sorry, just correction on that, deadline 4, deadline 7 and deadline 9. Track change version should include that track changes are colour-coded to correspond to the different deadlines at which the changes were made. And then at this point, if there are any questions, clarifications, either online or in the room. Yes, please do come forward. And you'll be fit by the end of the day. And if you, just for the audio and people at home, if you could please introduce yourself.
It's Patricia Newton, resident of Garth, and also someone who came back on the boat, as we call it, from Haitian to Douglas yesterday. I would just like to ask the panel, in terms of your site visits, are you intending yourself to enjoy a cruise from Haitian to Douglas to see all the wind turbines that are existing at the moment, and how this will impact on the views of the Isle of Man, the impression people give, etc., etc. But basically, are you intending to, if you have not already, and I'm sorry I can't, then I presume you've probably come by alternative means at the moment.
And so, Ms. Newton, we would find that extremely helpful if you were to include that in your submission to us at deadline 1 as one of the suggestions that you would make of us, and we will, of course, consider that.
Yeah. Just don't try and do it in May near TT time, you won't get a booking.
Yes, thank you very much. And turning to the applicant.
Amy Sterling on behalf of the applicant. Yes, just in relation to the updates to the draft marine infrastructure consent, the applicant is intending to update the draft marine infrastructure consent for deadline 2 of the examination. At that point, the applicant would propose also to provide a track changed copy of the MIC, so the changes are very obvious for those parties wishing to review them, and then we will take your approach for subsequent deadlines of changing the colour of the changes.
Very good.
Thank you.
And any other comments? There's somebody online.
Thank you, Madam. Michael Gregg, DLA Piper, for the various existing offshore wind farms. I just wanted to clarify a point which arises in relation to procedural decisions in relation to the documentation lodged by the applicant on 24th February. You already mentioned the non-material change request, which is included within that. There's also additional documentation which has been lodged in relation to wake loss. I just wanted to clarify if that's indeed been accepted into the examination.
I do believe my colleague, Mr. Smith, referred to the change request documentation that was submitted into the examination earlier today. At this stage, we have not made any procedural directions in relation to that documentation.
Yes, that's not that was quite my question, Madam. That it's not the change request. The letter doesn't just include a change request. It also has 2 documents on wake loss. So does the same position apply to those?
Yes, understood.
Thank you.
I will ask my colleague, Mr. Smith, to just respond to that point, please.
Yes. Thank you very much, Mr. Gregg. Yes, we do note that the receipt of the wake loss reports. And having considered those, I think it's very important to be clear that they are not part of the non-material change request. So they don't need to be considered as part of our view about what we will accept and when we will accept it. I think the best observation that I can make, given that they came in the same package, is that we will make clear how we propose to handle those documents. And we will do so. I think it would be appropriate if we make a very brief additional procedural direction to clarify exactly how that will be done. So that will come out in writing alongside our other procedural directions, and then it will place beyond doubt how we propose to handle those. What I would also indicate, given what has occurred there, that we had kind of 2 sets of material performing 2 very different purposes in one package, is a request for everybody that in order to enable us to manage very complex documentation, it's really, really helpful if a covering letter deals, accompanied by a range of documentation for a particular purpose, deals with one purpose and not maybe two or three in one hit. So if the applicant, for example, is making an equivalent submission again, it would be, I think, very helpful to us to see a letter dealing with wake effects and then the necessary documentation associated with it, and then a separate letter dealing with a change request and all of the documentation associated with that, so that we don't get the two mixed up. Does that help, Mr. Gray? I know it doesn't give you an immediate answer.
No, I understand that. Also, one of the reasons I'm asking the question is obviously we have a hearing on Friday, which includes, amongst other things, impacts on existing.
Let me be very clear to assist you on Friday, which is that I have read the wake effect report. I will be leading that hearing on Friday, and without prejudice to our decision about their acceptance or otherwise, they are there, they are published, and they can be referred to.
Okay, that's helpful, sir.
So just on that, we will of course be recording quite carefully some of the decisions that we will be taking after this hearing, after the preliminary meeting, and any procedural directions that we may choose to make after this, we will of course communicate to you. Yes, one other hand I see before I hand back to my colleague, Ms. Sahai.
Sorry to have to ask you for clarity.
May I ask you again? I know you have.
Lorinda Farragher, Golf Commissioner.
Thank you.
I'm sorry to have to ask you for clarity about the site visits, because I'm not clear about it. I've got a couple of places in mind that I'd like to take you that I don't think you've already been. And it would be quite nice to have some people there alongside me to explain the significance of the sites. Who can we invite to the meetings, these site meetings? Can we invite members of the public? How do you deal with that?
The deadline that we've specified, we would ask you to tell us where you would like us to visit, and ideally who you would like to accompany us on that. And at that point, we will consider your request. So our advice to you would be to be very clear about what you would like to see happen, and send that to us, and then we will consider it, and we will make a direction accordingly relating to it.
Thank you.
Thank you. Any other questions? Yes, gentleman at front. And again, if you'd be so kind as to introduce yourself.
Alan Desmond, I'm a resident of Garth. I thought it might be helpful to the room if the examining body actually informed us when they were appointed to the role, if that's okay.
For sure. Ms. Sahan?
So we were appointed as examiners in September. Most of us were appointed in September. Mr. Smith was appointed in November, and shortly afterwards, at the end of November, I believe, the application was referred to us. There are two slightly separate processes under separate sections, under separate provisions of the Marine Infrastructure Management Act. But the application was formally referred to us by the Council of Ministers on a date in November, the date of which can be found in our examination library reference, and I will request Mr. Randall to forward that to you. Could you explain to us the context of your question?
I just wanted to know, now you've given me the time when you're actually appointed, is that short notice for you, or is that usual notice? 3 months, 2 months? You're laughing.
That can vary, and we've had in the English context, the UK context, it varies greatly. You can be an examiner brought in at very, very short notice, but I can assure you that we've had the time to read application material, to visit the sites, and to consider all consultation responses and take that into account in order for us to be able to deliver on the pre-examination requirements that are placed upon us by MEMA with the time that's required to do them. And that essentially is to determine who our principal stakeholders are, what our initial assessment of principal issues are, and what is the procedure of doing this examination. So we've taken the time that we need. It is worth highlighting that early in the process, the date for the preliminary meeting was moved out by almost 7 weeks, I believe. The initial date was a date in January, and it was moved to this date in March. And that was primarily requested by the persons appointed to the examining body. So where we felt that time was inadequate, we requested that additional time.
That's reassuring. Thank you.
Okay, thank you very much.
Any other comment, questions? Applicant.
Amy Sterling on behalf of the applicant. Yes, I just have one clarification, one comment, if I may. First, for Mr. Smith, in relation to the weight loss and the suggestion that it would be discussed on Friday's hearing. We note that Friday's agenda is specifically dealing with shipping and navigation and fisheries. Agenda item 6D, which is the very last agenda item, other operational, social or economic effects at sea, may be broad enough to cover weight loss, but so the applicant ensures it has the right people in the right place at the right time. It would be great if Mr. Smith could clarify that before I pass over to Mr. Smith. Also, just to clarify that the applicant's expectation, given the documents hadn't yet been accepted into examination, was that it would provide the relevant commentary on the weight loss assessment, in particular its approach to mitigating weight loss at deadline 1. So we hadn't currently planned to speak to those documents on Friday, given they aren't currently accepted into examination. We can consider whether we are in a position to do so, if you could identify which agenda item that would be under. Thank you.
Thank you very much, Ms. Sterling. I think what we are mindful of here is the principal purpose of SIH3, which is, as you've identified, focused very strongly on shipping, fishing, navigation and safety at sea, navigational risk being the primary considerations there. However, the siting, design and layout of wind turbine generators, amongst other structures within an array area, do bear on questions of whether navigational safety is being appropriately addressed, but we are very, very acutely aware that there are also potential contingent considerations, of which wake loss is but one. One of the other factors that we are aware of is the relationship in terms of the marine safety environment between the location of your proposed array area and other existing and or consented or proposed array areas. So, whilst I will indicate very plainly that we will not be undertaking a detailed exploration of wake loss as an in-principle issue in that hearing, we will need to at least refer to the material that you have sought to place in. I felt that it was important pragmatically to indicate that without prejudice, the material that has been published would be able to be referred to by other principal stakeholders, because otherwise we can find ourselves in a situation where matters that bear on navigational risk are not fully considered in the specific issue hearing. Now, the risk that flows from that is that we are then not in a clear position about whether or not there are any possible approaches to siting or design change that might be matters that the applicant would consider. And so what I will indicate at this stage is a willingness, therefore, to consider enough of the necessary relationship between wake effect and any questions of siting, layout, design, and therefore navigational risk in that first hearing on that point, so that we don't end up with hanging questions on navigational risk that then flow down to subsequent hearings, because that, frankly, would waste your time, it would waste our time, and it would actually pose a potential risk, which was that we were just not getting to grips with siting and design related matters if they need to be got to grips with at an early stage. So that's the reason why I'm suggesting that we handle it in the way that we do. There is an inherent measure of pragmatism about that, but I hope that gives you clarity. And yes, in terms of where it then rests in the agenda, because it is contingent on our consideration broadly of navigational risk, there is scope for it potentially to arise across the agenda rather than just in that social and economic element of the agenda, if that makes sense.
Amy Sterling, on behalf of the applicant, the applicant's very clear position is there is no link at all between navigational safety and weight loss. I appreciate we're getting into the merits now.
Those are merits points.
Yes, I understand.
And you will have your opportunity to make those submissions in specific issue hearing 3, but I have to hold open the potential that others may have a different view.
Amy Sterling, on behalf of the applicant, that is noted. I guess I'm giving you early warning of our position on Friday, but I thank you for your clarifications. Yep. The other clarification I had was just in relation to the accompanied site inspection and the members of the public visiting. I'm sure the examining body will be aware and will make clear in their procedural directions in relation to the accompanied site inspection that isn't an opportunity for indeed the applicant to lobby for the development or the public to lobby against the development or indeed for the development. And so any requests and directions at the accompanied site visit should be entirely factual rather than a planning case. Thank you.
Thank you for that. And as you will have recalled from my comments, I was quite explicit to say accompanied site inspections are not an opportunity to discuss the merits of the application, but to point out facts or features that are there for us to see, but certainly not into the merits of the case. And we will be reminding anybody that attends an accompanied site inspection at the beginning of the site inspection of those points, just in case anybody may have not remembered or haven't been here or hasn't read that. So, okay, I see a few more hands on the procedural directions. Would you like to come forward and introduce yourself? I know you have, but helpful for the audio.
Just to speak on that last point from Ofsted's representation, Garth Commissioners are a professional organisation. We are
sorry, just for the audio, and we will keep doing this whenever we have
Excuse me.
hearings.
Yeah, Martin Royal, Clark, Garth Commissioners. Just to clarify, Garth Commissioners are a professional local authority who engage in many incidents where we visit sites, and we are fully aware of the procedures and how to handle ourselves at those kinds of events. So certainly there will be no lobbying on our part. Thank you.
Are there any other points that anybody would like to raise in relation to the procedural directions that I have run through today? Okay, in which case I'll hand myself back to Ms. Sahai.
Thank you, everyone, and thank you to everyone in the audience for your attention today. Having reached the end of all these agenda items, I will shortly close this preliminary meeting. But before I do, some reminders about the business of the examining body for the remainder of the week. We will be conducting our very first public meeting to enable people to speak and provide their views on the application today. The public meeting will be held in this room. It'll start promptly at 4 p.m, but you'll be able to register both online and in person from about 3:30 p.m. onwards. Tomorrow we will be holding our first specific issue hearing into the draft marine infrastructure consent and other strategic matters. Please note that we will be using a new venue for that hearing. Please don't come here. The venue for that hearing is Comus Golf Club, Mount Murray Back Road, Douglas IM4 2HT. The venue will be open for registration from 9 a.m. Teams, you can register on Teams from 9:30 a.m. as well. Sorry, it was 9:30 a.m. for both registration processes, and we will start promptly at 10 a.m. We anticipate that the hearing will proceed for a full day. Similarly, on Thursday, we will hold specific issue hearing 2 on environmental matters, and on Friday, specific issue hearing 3 into shipping, fishing, and navigation matters. All the hearings are being held at Comus Golf Club and will start at 10 a.m. with registration from 9:30. Right, at this point I will turn to the audience to see if there are that you think we need to take into account before we close this meeting. I have nothing from the audience in person and nothing from the virtual room either. Ms. Sterling, anything further from the applicant?
Amy Sterling on behalf of the applicant, nothing further. Thank you.
Thank you very much. Then, on behalf of the examining body, I would like to thank everybody who's attended today and for your contributions, and the Cabinet Office staff for the arrangements. The time is now exactly 11:50 a.m. and I'm now closing this preliminary meeting.